I didn't quite hear that, please. Okay, I see the recording sign, so it's recording.
Yes.
Please, can anyone see my screen? I just want to be sure we all see my screen.
Senior, I can see it from.
Yeah, I can see your screen.
Yeah, we can see.
Great. So, my name is Joel Telfer Jr. I would be facilitating today's discussion on the law of interpretation, and the goal is to, as much as possible, provide you with some grounding in respect of your approach to the study of the law of interpretation. Invariably, it comes to light that interpretation is one of the more difficult courses to comprehend in part two, primarily because of the sheer volume of material that you may have to consume and the amount of technical expressions and words and, if you like, concepts that you have to grasp. So, because of the huge load of cases and the concepts that you also have to grasp, there appears to be a problem. And so, some of us find it difficult in understanding the basics of interpretation and why exactly, or how exactly to approach the study of interpretation. So, the goal of these sessions is to provide you with a broad overview and some guide in respect of how you may approach the study of interpretation. And then we'll go into the nuances of some of the topics that you may have treated thus far, as I've been reliably informed by some of your colleagues. And so, just by way of ground rules, if at any point in time during the presentation there's something I'm saying that you do not understand or you do not agree with, you may please use the raised hand feature. I'm sure I'll see it and then I'll call you. It will be more helpful if you could use that feature rather than just butting in to interrupt the session, because then that becomes a bit chaotic. So please, just so that everybody could benefit to the maximum from the session, just use the hand raised feature and then we'll be able to go into it. Next thing I need to put out there is the slides I'll be sharing on the screen are not exhaustive of what we'll be discussing here. So I'm sure you see that there are only 6 slides. They are just supposed to provide a guide as to how the discussion will take place. I don't believe in overly worded slides or heavy slides, because the view is that that also detracts from the discussion that we could possibly have in terms of many other things that we may look at. So that is just by way of preliminary matters. Great. So for the next 3 days, we'll look to try and introduce the law of interpretation again. We'll highlight the basic things to look out for in the study of interpretation. We'll identify preliminary issues of interpretation. We'll look at the approaches to interpretation, which is quite interesting. And then we'll try and conclude with an introduction to non-statutory interpretation. Admittedly, there's a lot that we have to cover within the next 3 days. We may not be able to exhaust everything that I've set out here for us to exhaust, but as much as possible, we'll try to make progress and cover ground. And so, even though we will not be rushing through the process, we will try and deal with the issues as and when they come up, with the hope that you gain as much as possible from the discussion as is available. So, again, just by virtue of disclaimer, the content that we'll discuss or the scope of our discussion is not exhaustive of everything I've covered in class. The goal is to provide you a broad overview that grounds your understanding of the course. So if there's something that you think that we ought to address, and by the end of the session I have not addressed, you can bring it up by way of question. We'll discuss it, or you can apply my disclaimer in that regard, hopefully, and then that should be able to deal with it. So let's continue with the introduction to the law of interpretation. I always say that the best approach to studying any course at the law school or even LLB is to understand why we are studying the course in the first place. Like, what is the point? What does the course do in terms of furthering your legal journey? Why are we even studying this course in respect of the curricula at the law school? Because then understanding why you are studying the course would ground or would enable you to know how best to approach the study of the course. Understanding why you are studying the course would enable you know how best to approach the study of the course. When it comes to the law of interpretation, it is simply this. The idea behind the law of interpretation is this, that oftentimes there may be instances where words used in a document, a statute, or a constitution may lend itself to multiple meanings. As we know, there are instances where you may say one thing, and depending on who is listening to you, there may be instances of, if you like, one interpretation or the other. So, for instance, there's a way in which if you send a text with an exclamation mark, it conveys one message, and if you send it without the exclamation mark, it also conveys another message. So you may have said, let's say, Kofi is going to school by virtue of a text message to a friend. When you send Kofi is going to school, that text message alone may not connote any animosity or anger or anything of the sort. But as long as an exclamation mark is added, then it is an entirely different thing that we are looking at. It is also possible that in your conversation with somebody, the way in which a person perceives one thing that you say will be different from the way in which another person perceives it. So, because of several instances or several factors such as cultural backgrounds, basic understanding of the English language, the person's, if you like, predilections or biases, there are different ways in which people would understand what you say or what you write. Because of that ability for different ways in which people view or perceive things, there's a need for us to establish some basics. We have to say, look, at some point in time, we cannot say this person's interpretation is correct or this person's interpretation is wrong. We have to, as a society, as a body of law, establish some basic rules that enables us reach, if you like, a certain consensus on what the meaning of language is. That is the goal of the law of interpretation. The law of interpretation is set out as part of the curriculum at the law school, such that when you find language, words, sentences, statements used in documents, statutes, or constitutions, you come to a certain understanding that those or the language used therein may lend itself to one meaning or the other. As to how we go about choosing the meaning that is most appropriate given the circumstances, that is why we are studying the law of interpretation. Please, I hope that is clear. Is there any confusion? Do I need to take it again? Okay. So moving on, having established why we are studying the law of interpretation. Okay, is there a question?
No, please.
Okay. So having understood, and please, if I tend to talk fast sometimes, so if you think I'm going too fast, you may draw my attention, I'll slow down. Having understood the reason why we are studying interpretation, the next thing to look at is how to go about the study. I say this, that The study of the law really is mechanical, but interpretation is even more mechanical. Understand it this way. You are faced with a set of facts. The set of facts are A. Suraj, please mute. Okay. The set of facts, you are faced with a set of facts. The set of facts are A. You also have a certain understanding on the rules and approaches to interpretation. That is your B. Your answer to the question, which is your C, would be applying the set of facts or applying the rules that you have come to understand in your interpretation class to the set of facts to get the meaning or the true meaning of what it is in A. I'll take it again. You have three variables, A, B, and C. A being set of facts, the dispute, the contention that something contained or a statement contained in a document, a statute, or a constitution. So I'll be using DSCs. Anytime you hear the term DSCs, it simply means document, statute, or constitution. So a statement or a word contained in the DSC is being controverted on. So it's subject to the meaning, multiple different interpretations. So for instance, one thing you find topical in our jurisdiction now is the effect of Article 108, where the president says that when there's any financial implication arising out of a bill, it ought to be a bill that has originated from the president in accordance with Article 108. Parliament disagrees. Parliament says that a combined reading of Article 106 and 108 demonstrates that a private member's bill may originate in Parliament, and even though it may have incidental financial obligations, if it is not a fiscal bill which is for instance, appropriations, a tax bill, then it is not within the contemplation of 108. These, and I'm sure by the time we get to the construction of a national constitution and interpretation of national constitutions, this will come up in your discussions again. But these are two broad views. Same constitution, presidency and executive are looking at it one way. The parliament and the legislature is also looking at it another way. So that's a set of facts A. What should the Supreme Court in this situation, when they are called to interpret the constitution, do? They are to apply the rules of interpretation in B. The rules of interpretation are what we are studying. That is the focus of the course. That when it comes to a document, interpret it this way. When it comes to a statute, interpret it this way. And when it comes to a constitution, also interpret it this way. And also, in viewing all the rules of interpretation, there are various approaches. And so by applying the rules and the approaches to the variable A, which is a set of facts, you get C, which is the meaning or the true meaning of the words as used in the DSC. So just by way of summary, anytime you are faced with an interpretation question, look for the set of facts. Where is the dispute? The dispute is here. The dispute is in the meaning of Article 108. What does it mean to say a bill has financial implications? Then refer to the rules of interpretation you have studied. So you study the literal meaning, the technical meaning, the modern purpose. Then you come to understand the fringe meaning, the secondary meaning, the canons or linguistic canons of interpretation. You apply it and use them generis. You also apply the approaches to interpretation, the modern purposive approach. A combination of all that you have studied will lead you to one point, which is the best rule to apply given the set of facts. When you have found the best rule to apply given the set of facts, you marry the two. Set of facts, best rule to apply, that will give you the meaning or the true meaning of the words as used in the DSC. So every question you answer in the interpretation class, every question you answer in an interpretation exam must lead you to one point. What is the meaning of the word or the statement? You must, at the end of your answer, in your conclusion, be able to provide a meaning based on the combination of the facts and the rules and approaches. That is what will lead you to C, which is the true meaning of the document. Please, I hope this is clear.
please.
Yes,
Any
please.
questions? Does anyone have a question? It's important to me that you get this, because once we establish this, it will be easier to proceed.
I think you should
So,
go over again. I think you should go over again concerning the end means. I mean, what you should expect. Like we were saying, if you are
okay.
answering a question at the end of it, what should you see? What should you be able to produce to know that I'm there or I've achieved it?
Okay, I'll do that.
Thank you.
So, for instance, let's assume during your June, July exams, they'll give you a set of facts that is similar to what we are experiencing in Ghana's political space right now. If you're not familiar with it, I'll take you through again. So, there's a private member's bill that has been passed by Parliament. The bill's intention is to, if you like, remove the death penalty from our statute books. So there's an amendment to the Criminal Offences Act and the Armed Forces Act to effectively strip those acts of the power, or restrict those acts of the power of vesting in judges the power to grant the death penalty for certain offenses. The president says he doesn't disagree with the substance of the bill. He thinks it's a good bill. He, however, indicates that because the bill did not originate from him or somebody designated by him, it is in clear contravention with Article 108. If anybody has their constitution, can they please read Article 108? Can somebody please read Article 108 of the Constitution?
Hello?
Yes, Faisal.
Yes. Article 108 says, Parliament shall not, unless the bill is introduced or the motion is introduced by or on behalf of the president, A, proceed upon a bill including an amendment to a bill that, in the opinion of the person presiding, makes provision for any of the following. I, the imposition of taxation or the alteration of taxation otherwise than by reduction. II, the imposition of a charge on the consolidated fund or other public funds of Ghana, or the alteration of any such charge otherwise than by reduction.
Faisal, please stop there.
All right.
Okay, so that is where the contention is. That is where the debate is. The president contends that by virtue of Article 108 AII, because there will be costs of incarceration and some other things. Essentially, what he's saying is there are financial implications of the private members bill. By reading of Article 108, which indicates that Parliament shall not proceed on any bill which has financial implications unless it is introduced by the president, his understanding of 108 leads him to the conclusion that what Parliament did was unconstitutional. Okay? He's saying that the Constitution is clear. So, for instance, if there's going to be a law that would introduce or impose a new tax, it has to come from Parliament. It has to come from the president. The bill must originate from the president. If the bill has financial implications in terms of a debit to a consolidated fund, it has to come from the president. That is what 108 is about. That is one view. The other view is that Article 106, read together with 108, grants Parliament the power to pass private members' bills. Private members' bills means that the bill was not initiated by the president, but the bill was initiated by a member of Parliament. The only restriction on the power of Parliament to pass private members' bills are the ones set out in Article 108. So admittedly, on both sides, they agree that there are restrictions on the powers of a member of Parliament to introduce a bill. If the bill has financial implications, it has to come from the president. The debate is what is the meaning of the term financial implications. The president says even if the consolidated fund will lose 1 cedi by virtue of the bill, then it is a financial bill within the contemplation of 108, and so consequently any attempt to make a private member's bill to that effect would be unconstitutional. So he says that in substituting the death penalty with the life sentence, the cost of catering for the prisoners would be a charge on the consolidated fund. And on that premise, Parliament could not have sought to pass a law that cost the consolidated fund money. Parliament disagrees. Parliament says that by any stretch of imagination, any bill would admittedly cost the consolidated fund money. But what the framers intended in Article 108 were financial bills. So, for instance, the appropriations bill that would outline the expenditure of government for the year, or the imposition of a tax or the remission of a debt or a loan. So it has to have fiscal implications. Fiscal spelled F-I-S-C-A-L, fiscal implications. And so a tangential or incidental expenditure on the consolidated fund would not necessarily be a restriction on the enactment of private members' bill. These are two contending viewpoints. So these are the variables you find in A. President believes one thing, Parliament believes in another thing. You, as the judge, Justice of the Supreme Court, Faisal JSC, sitting at the Supreme Court complex in Accra, called to interpret the meaning of Article 108, read together with Article 106, and determining the matter of whether or not a private member's bill can cost the consolidated fund money in any way or form, even if it is incidental. In approaching this, everything we are studying in the law of interpretation class becomes topical, because then you study the approaches to interpretation, you study the rules of interpretation, and you study things such as linguistic canons and aids. They are called aids to interpretation. So there are approaches to interpretation, there are rules of interpretation, and there are aids to interpretation. The approaches determine the viewpoints as to how the various scholars, so the approaches is much more of a political science class and a history class, how the people form, or jurisprudence if you like, how people form their ideas, and based on their school of thoughts, how it informs the way in which they interpret a document. The rules are such that for every type of document, the courts have over time, together with the Interpretation Act, established how to approach interpreting those documents. So for instance, when you're interpreting a will, the rules are different from when you're interpreting an act of parliament. And the rules are also different when you're interpreting a constitution. So there are, for instance, when it comes to the intent, it is more restricted when you're looking at a will. But when it comes to an act and a constitution, it is more broadened. Those are the rules of interpretation. And then there are aids. So there are things such as the date of the enactment, the schedule, the side notes, the memorandum to the act, if it's an act, and so many other things that aid you in coming to the authorial intent or the true meaning of the text that you are trying to interpret. And I'm saying that by a combination of the rules, the approaches, and the aids, you'll be able to find the best means to interpret the dispute that is in contention, which is Article 108. So by combining A, B, and C, by combining A, which is the dispute, and B, which is the approaches, rules, and aids you have studied, you should be able to get C. So at the end of the day, you, Faisal, sitting in the Supreme Court, should be able to interpret the meaning of Article 108 to provide an exhaustive, if you like, answer to the question of what is the true meaning of Article 108. Because remember that oftentimes the disputes that the courts are faced with is English language. And so if that were the case, we would not even have had basis for interpretation. We'll say, but this is English, everybody understands. But because we appreciate that there's a nuance and there's a certain technicality that comes with legal language, and when it comes to documents that have legal effect, that is why we do interpretation. That is why we don't allow people sitting in Makola, or people sitting in, Parliament, or people sitting in the Jubilee House to do the interpretation. We say, put it before a court of competent jurisdiction, let them apply the rules of interpretation, and then that will lead us to a conclusion as to the meaning. So just to summarize in terms of what is expected of you in an interpretation question, you will be given a narrative set of facts all the time. I mean, there are instances where some of the questions will say write short notes on, maybe some of the approaches or some of the rules or some of the eight. But the bulk of the questions are centered this way, that you'll be given a set of facts. When you are given those set of facts, you'll be asked to provide a meaning to the to the dispute in question. You are called on to resolve the dispute, and I'm saying that it behoves on you to resolve that dispute in a manner that applies the rules of interpretation, the aids and the approaches that you study in your interpretation class. And so when you have that understanding in mind, anytime you are faced with a set of facts in interpretation, always ask yourself, how best am I going to resolve this dispute? What are the tools available to me to resolve this dispute? And at the end of the day, what is the more likely conclusion I can come to? The next thing you must also notice, or you must also pay attention to, is that oftentimes the questions on interpretation are real life events. So they are either cases that have happened in the past, or they are topical issues that are happening currently. For each of them, you cannot, as a matter of principle, attempt to reinvent the wheel. And I say this with a lot of emphasis, that if a superior court or the Supreme Court has provided, let's say, an interpretation of the meaning of a certain word in the Constitution, and you are answering a question with the same set of facts, your best bet is to apply what the Supreme Court provided in terms of the interpretation. And if you have a contrary view, add it as an addendum. This is important because it goes back to the need for you to read your interpretation cases. And the interpretation cases may be a lot, and some of them span various different subsets of interpretation. So for instance, for an attorney general, you come across it in many. So when you're talking about the purposive approach interpretation, you hear for an attorney general. When you come to interpretation of a national constitution, you hear it again. When you are reading the cases, you must read it in context of the topic that has been provided to you. So for every topic, you'll be given cases. What I'm saying to you is that if you read the cases in the context of the topic that is provided to you, it will be easier for you to streamline and know what is necessary. So for instance, you are faced with a question that requires a discussion on the modern purposive approach to interpretation. And so your Asari and Attorney General 2004 is important. So even though there are several other points in Asari and Attorney General, because you studied it under the modern purposive approach to interpretation, when you are faced with a similar set of facts, it's easier for you to apply them. So realistically speaking, I don't think you can read every case in interpretation, but there are some cases that form the understanding, that provide the grounds with which you can understand many of the concepts. And some of these cases, your lecturers will mention them quite a lot in class. And so just by following some of the cases that they are mentioning, you'll be able to identify that, no, this is a case that if I read, I should be able to at least get the understanding. And then you add some three other cases to sprinkle, just to, or to make you distinguish you from being a 49 student to a 51 student. At this stage, you are in part 2, so you know the strategies on how to, just go over the 50 mark, and how to also excel at that point in time. So that is it by way of the law of interpretation, how to approach it, and what the effective study plan can be. The material is a lot. You'll be required to deal with a lot of technical terms, but if you take it one step at a time, first forming an understanding, what does this mean? Once you understand what it means, look for a case or look for cases that support it and put it down, and then try and look for a question that will arouse your curiosity in respect of that set of topics that you have studied, and apply them. You'll come to realize that by the time you get to June, having tested yourself with each of the various phases, interpretation will be one of the easiest things that you can come across. Is there any question? If not, we'll proceed to the preliminary issues of interpretation. Any question, please? Okay. In terms of DSCs, interpretation is the process of identifying the meaning of words used in those DSCs and determining the scope and legal effect of those words. People of God, what I'm saying is interpretation is not just identifying the meaning of a word. That's one, an ordinary person with a dictionary can do it for us. The point of interpretation is to identify the scope and legal effects of those words after you have established the meaning of the words used in the document. So your work as, and in many instances, I'll be referring to you as a judge. So your work as a judge in respect of interpreting a document or the words used in a DSC doesn't stop at ascertaining just the meaning. When you have ascertained the meaning subject to any rule of law, you must also be able to establish the scope and legal effects of those words. Because, for instance, in a constitution, if you find, say, let's go to Article 2.1. Faisal, please read Article 2.1.
Article
Clause 1 of Article 2, please.
Okay. Clause Article 2 say Article 9 of the Constitution is amended by the repeal of
Article 2.1. Okay. Supremacy of enforcement of the Constitution.
All right. Article 2 say a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment, or B, any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect.
So the Supreme Court has explained the meaning of the word person used in Article 2.1. So if you may recall, in MPP AG, the SIBA case, and some in Attorney General, there has been a set understanding that the person there connotes either a natural person or a legal person. And for a natural person or a legal person, they ought to be citizens of Ghana. We'll come to explain how a legal person is classified as a citizen much later. But for a natural person, the person must be a citizen of Ghana. You don't see the word citizen used there. You don't see the word legal or natural person used there. What you find is the use of the term person. So if the court had stopped at defining person, we would not have known the true scope and legal effects of the words as put together in the context of Article 2.1. So this example, or the reason I said this example, is to demonstrate to you how, just by the dictionary meaning of the word person, what you would find, let me just pull this up for you. Dictionary meaning of person. A human being regarded as an individual. That's all. A human being regarded as an individual. So if Bamford Addo sitting in that case had determined that person simply meant a human being regarded as an individual, that would have restricted the scope and legal effect of Article 2.1. But in interpreting the meaning of the word person and in ascertaining the meaning, she was able to ascribe the term legal and natural person and a citizen of Ghana combined. So when you read SIBA and Psalm number 2, it leads you to that conclusion that Article 2.1 relates to natural and legal persons and citizens of Ghana. They are the only persons or entities that can bring an action in the Supreme Court for declaration that an act or omission is inconsistent with the Constitution under the Supreme Court's original jurisdiction, as set out in Article 131. So it's important to point out that in interpreting a deed, a statute, or a constitution, a DSC, or a document, subject to any rule of law, you don't just apply the meaning of the word, but you must also know of the scope and legal effect of those words. To that effect, when we are looking at questions of interpretation, two issues arise. One, there are those which arise from the terms of the DSC alone, that is before any set of facts have been presented for its application. And two, those which arise in application of the DSC after a particular set of facts. We are more concerned with the second one, because just by a layman ordinary reading of the Constitution, sometimes a dispute does not arise. So in our jurisprudence, we have never been called on to interpret the meaning of Article 108. It has never been a topical issue before the Supreme Court. And so everybody has assumed a certain understanding of Article 108. However, because a particular set of facts have arisen in the context of our national life, then the second arm of interpretation arises, and we are called on to provide some scope or some understanding in respect of the meaning of the provision as set out in Article 108. Please, is this clear?
Yes, please.
So I want you to note the following from the definition that has just been provided, right? That one, interpretation in law, and I emphasize this, is not only concerned with the meaning simplicity of the words. It is not only concerned with the meaning simplicity of the words used in the DSC, but is concerned with the scope and legal effect. What does it mean to say the legal effect? The legal effect of a word explains the legal consequences. So a word used in isolation may not have any effect. For instance, if we say annulment, when a person, and you are becoming scholars of family law, when a person says annulment, basically, it has a different meaning when it comes to family law. And so annulment, as used in our ordinary expression and language, has a different effect when it comes to family law. Who can assist us as to what the effect of annulment is? Like, what does it mean to say annulment of a marriage? Does anybody have any idea? Oh, okay. Let's proceed. I'm sure as time goes on, this is a sharing would those of you.
Yeah. Hello.
Yes, Eric, go ahead.
Yeah, I think for annulment, when we say annulment, it means in family law we can say that it's about marriage that is void or voidable, which cannot be used in terms of, let's say, a marriage that is valid.
Mhm.
So, in terms of, let's say, annulment, when we talk about it, it's just in an ordinary language, English language. If you annul something, you sort of invalidate it.
Okay. That's so when you come to study the nuances of annulment and divorce, you know when annulment is used and when divorce is used as well. But the point I was making to you is ordinary words carry legal effects when they are used in documents, statutes, and constitutions. And so they must be viewed in that sense when you are understanding them. And that is why we say we are not just concerned with the ordinary meaning of the words or the meaning of the word simpliciter, we are also looking at the legal effect. The example of person would also suffice. I want you to note this, that when it comes to interpretation, right, there are several competing theories and approaches to interpretation. There's no one size fits all. The rules, the principles, on how to ascertain the true meaning of a language used in a document, statute, or constitution are varied. There are a lot of them. It is not correct to say that one approach runs through all. I mean, there are basic understandings that provide a certain context, but there are several competing theories and approaches. And oftentimes, people are influenced based on their school of thought as to how to approach interpretation. So you'd find that somebody like Justice Datiban was a purposivist. That word, when I'm pronouncing it, I have to take my time. Was a purposivist. And so he was, if you like, the biggest advocate of the modern purposive approach to interpretation when it comes to constitutional interpretation. There are those like Justice Taylor and those before him who also believed in a certain sense of literalism. There are those who believed in originalism and those other approaches. They are varied. They are different. It's important to also understand that even though these rules are different, even though these rules are varied, they must bring you to one conclusion and one conclusion alone: the meaning and the legal effect of the word used in a document. So oftentimes we run the risk of, because we have a broad understanding of all the theories, when you're asked a question, you want to display, oh, originalism, political process theory, this, that. And so you write all about those theories without identifying or without answering the question that is before you. My small advice to you is that your ultimate task is ascertaining the meaning, scope, and legal effect of the language. And so in all your doings, in all your applying of your knowledge, make sure that you are able to determine the meaning, scope, and legal effect of the language, because that's the point of interpretation. In Ghana, it is now an established matter of law that when you are looking at a document, a statute, or a constitution, the object of the interpretation, the whole point of the interpretation, is to find the intention of the author, the person who wrote the document, and then give it its intended meaning. So intent has become the gravamen, if you like, or the bulwark, the basic underlining feature when it comes to interpreting a document. You must be able to, as a matter of principle, determine the intent, what the approaches, what the rules, what the aids provide us are different mechanisms for identifying the intent. But at the end of the day, the overarching principle is you must be able to provide a meaning that is consistent with the intent of the author. There are those who believe the intent can be evinced one way, and there are those who believe it can be evinced another way. Like I said, so there are those who say just by reading a document, a literal meaning of the document will provide you with the true intent of the author. Some will say, well, look at other factors, such as what were the prevailing circumstances at the time that the document was authored? What must have been operational on the mind of the author at the time of his making the document? These are all things that will be helpful. So for instance, you would know by now that when interpreting a constitution, a literal approach is not desirable. That, for instance, if you refer to the words of SOA GSC, or SOA GSC, and to an attorney general, where he says a constitution such as ours, has a spirit and has this letter, and so a strict doctrinal approach to interpreting the constitution is most undesirable. And so we have come to a place to understand that in determining the intent of the framers of the 1992 constitution, a literal approach is not the best. There are other approaches that have evolved over time. But you also come to learn when it comes to construction of documents such as wills, that
Hand has been raised. Hand has been raised. I do want to ask a question.
Okay, Ahojo Farms, please ask your questions. Sorry. Ahojo Farms, please unmute yourself and ask your question. Should we proceed?
I think there was a mistake. I think we can proceed.
Okay, great. So let's proceed. But is there any? Are you clear as to the things I'm saying to you? Am I making sense?
Yes, you are.
A lot of sense.
Great. So
Very, very, very.
great. So again, at the risk of sounding repetitive, the main object of interpretation is to ascertain the meaning of language. The MSc here means meaning, scope, and effect of language of a DSC, which best effectuates or reflects the intention of the author. So let's do a little bit on intention, right? And like I said, there's a legion of authorities that indicates that the point of interpretation is to evince the true intent of the person who made the document. So under statutes, if you look at Benyon on statutory interpretation, he says that the sole object in statutory interpretation is to arrive at legislative intention. Benyon's book on statutory interpretation, if you have access to the book, you may check it. He says the whole point of statutory interpretation is to arrive at legislative intention, which is the lawmaker. Again, I made the point for an attorney general when it comes to constitutions, where SOA JSC noted that we must take cognizance of the age-old fundamental principle of constitutional construction, which gives effect to the intent of the framers of this organic law. And also, Aqua JSC in Republic versus Tommy Thompson, where he said, what is required of us is originality in the interpretation of the Constitution, paying attention to the words in such a way as to advance the intent of the framers. And so, when it comes to statutes, when it comes to constitutions, when it comes to documents, so again, another hack. You have been asked to interpret a document. Your first question you have to ask yourself is, what was the intent of the person who made the document? Because understand it this way. When I write a document, I intended for the document to mean something and to have a certain effect. I made a will. I intended that person A, B, C benefits from the will, but I may have provided some ambiguity, whether patent or latent, in respect of the expression of the terms used in the will. Your first goal as a judge, faced with interpreting the meaning of those words as used in the will, should be to determine my intent. Parliament has passed the law. Recently, the Supreme Court found that the Imposition of Restrictions Act was unconstitutional. So Parliament has passed the law. Before the judge can determine anything else, if there's a question as to the meaning of the words and the scope of the words used in the, if you like, that document or the Act of Parliament, you must ask yourself, what did Parliament intend? What was the intention of the lawmaker? Similarly, when it comes to the 1992 Constitution, you have to ask yourself, what was the intention of the framer? So please, when it comes to interpretation, intent is important. And everything we do would be a discussion on how to best evince the intent. So in terms of the aims, the object, or the purpose of the author in using that particular language in the DSC is what excites our mind in the class on interpretation. How we get to that point, the tools we use, the principles, authorities, guides, and the likes that we use to get to that point is the object of interpretation. Is this clear?
Yes, please.
Please, any question?
No.
I hope we are building a trajectory. I know, again, nobody will ask you some of the things we are discussing here. Nobody will ask you what is the object of interpretation. This is not a social studies class, so nobody will ask you those things. But I find that if you are able to ground yourself in these basics, everything else will just come easily to you. So if there's a certain confusion based on what we have discussed so far, please draw my attention to it and I would address it. I'm giving a minute or two for those purposes. Okay, let's proceed. So having outlined that intent is the basic view or the overarching view that sorry, just a second. Just a minute, please. Great. So having established that intent is the overarching view when it comes to interpretation of documents, can anybody just hazard a guess as to what could possibly be the, if you like, instances that give rise to difficulties of interpretation? So under what circumstance do you think that we may be called to interpret a document? Does anybody want to try? Under what circumstances will we be called to interpret?
One of the circumstances which a document can be interpreted when there's an ambiguity in the document. And again, when there is an, let me say, there's a clash of words. There is a proper word for that, but I've forgotten. Let's say if there is two lawyers argue on one provision and there is a conflict, then that words or provision must be referred for interpretation.
Excellent. That was a good attempt. So language is not, unfortunately, language is not linear. It's not set in stone. And like I said at the outset, it's important to understand that because of biases, cultural prejudice, relative understanding of the English language, and general problems, there may be instances where conditions will arise that will give instances to interpretation. I'm also making this point because, or I'm getting to this point because when you understand the condition that has given rise to interpretation, or when you understand instances where interpretation may arise, then you know how to resolve the dispute. So if you don't know the problem that has arisen, then you don't even know what dispute you are resolving in the first place. And so it is very important to understand that you must know the difficulties of language, and understand that because of the very nature of these problems, once you know what problem you are dealing with, then you know how to resolve it. So like the first one that he mentioned is the ambiguity of words. The English language is such a beautiful one because one word could lend itself to multiple different meanings. And I'm sure by this time, those of you who have been, had a discussion with Mr. Pokwajman, he has given you the example of nowhere is, that's, I mean, somebody should remind me now. Here is, I think it's in the manual as well, but there's that example and
God is now
the-
here.
God is nowhere. And God is now here. I think so, right?
Yes.
So just in that statement, you could see how, depending on who is reading the document and how they are reading the documents, the word could lend itself to multiple different meanings. So a word can be ambiguous when it has more than one meaning in the context of its use. So for instance, if I say our parents bore us, if I say our parents bore us, one person may interpret it as our parents gave birth to us. Another person may interpret it as our parents annoy us, or our parents in pidgin they vex us. You get what I'm saying? So the potential of a word to have multiple different meanings is what grounds the sense of ambiguity. And in practice, the authorities try to provide different kinds of ambiguity, such as patent and latent ambiguity, general and relative ambiguity, and then we have semantic, synthetic, and contextual ambiguity. Who can tell me the difference between patent and latent ambiguity? Any ideas? Those of you, everybody has done equity, the law of equity and succession. You should be able to tell me what patent ambiguity and latent ambiguity is. And everybody has done commercial law. So if we say something is a patent defect and a latent defect, that should also come naturally to you. Any ideas?
Okay, let me try.
Mhm.
For patent, we say that for that ambiguity, it's clear on just on reading it on the surface of the document. You can see clearly that that is clear. So we can say it's patent. But when it's latent, you need to do further reading and situate the whole thing.
I'm losing you, Eric.
Oh, okay.
Please try again.
Yeah, I'm saying that when we say patent, it's that kind of ambiguity that is clear. Just looking at the word or the document, you can see that there is some kind of ambiguity. But
Mhm.
when we say latent, you need to do further reading, and probably if it's that particular word, you need to put it in the context in which that particular word is seen, and several other things before you would be able to get the kind of ambiguity you want to look at. So clearly,
Excellent.
the patent is just visually seen, and the latent is a little bit darkish. Let me put it like that. You need to do further reading for you to get the meaning.
Excellent. So when we say an ambiguity is patent, it means on the face of the document, just by looking at the words, we can tell that it lends itself to multiple different meanings, like he said. But latent arises when you apply it to a factual situation. So just by reading the words, you may not think it's ambiguous. So for instance, I make a will, and this is a case. So I make a will that says I'm donating or I'm gifting to my nephew, Kwame Ansa. My nephew, Kwame Ansa, $3 billion. Indeed, I have one nephew, but that nephew is called Kojo Ansa. Or I have a son who is called Kwame Ansa, but in my will, he was described as my nephew. This is a situation where a statement I have made could lend itself to an ambiguity applied to a factual situation. Because when you take the words contained in the will itself, there's no ambiguity in terms of patency. But when the words are used in a manner that's when you apply it to a set of facts, creates a certain sense of ambiguity, then there's a problem. So, for instance, if I have two nephews called Kojo and San, which of the nephews are we talking about? Right? So I say I give to my nephew Kojo and San $2 million, but I have two nephews with the same name. That is a patent ambiguity. I'm sorry, that is a latent ambiguity because on the face of it, just by looking at it, it doesn't lend itself to multiple different meanings. But when you apply it to the set of facts, that indicates that, well, I could potentially have two nephews with the same name. That is when you would find something called a latent ambiguity. Another reason for, so that is it for ambiguity. So oftentimes, and ambiguity usually, this example I've given you, when we come to study interpretation of words, it will be very important. So please keep it in mind. Sorry, you would need it in that discussion. Vagueness of words. So the first one is ambiguity. The next reason we interpret is vagueness of words, because most words we use daily can often have a number of settled meanings, which are, subject to strained meanings or fringe meanings as well. And it creates a problem of determining the exact meaning in interpretation, because some words, for instance, have a generic character, and some words are open textured, right? And so just by looking at the words in and of themselves as they are used in the DSC, without any interpretation to determine the authorial intent, we might not arrive at the true legal scope of the words used. So because words can be subject to a degree of vagueness, and they may lend themselves, because of the open textured nature of those words, to several different characteristics and several ways in which they can be used, it creates a certain sense of uncertainty. And when that uncertainty arises, we may be called on to interpret. Another basis under which we may be called on to interpret is the fact that society is also constantly evolving. We'll come to that a bit more when we are looking at the interpretation schools of thoughts or the approaches to interpretation. I don't know if you've heard about a recent case adjudicated upon by the United Kingdom Supreme Court, where they have outlined that inventions generated by artificial intelligence cannot be the subject of trademark protection or something like that. A few years ago, issues of artificial intelligence would not have been before the courts. And so the courts would not have been called upon to interpret statutes or, let's say, constitutions in the context of artificial intelligence. But as society is evolving, the rules ought to be dynamic. Remember that we reflect on the words of SOA JSC again. The rules ought to be dynamic. And so there's a constant need to give effect to the intent, especially when it comes to statutes and constitutions of the lawmaker, in a way that doesn't strip the law of the very reason of its existence. And so interpretation also arises in that context when there are changes in social or prevailing values, economic circumstances, or sometimes even the meaning of words. Those are instances where may require a situation where we need to be constantly evolving as a society and looking at the meaning of words as we go along. The meaning of words as used in the Constitution in 1992 may take a different coloration in a few years down the line, but it all goes, or it must all go down or back to the same point as what was the intent of the lawmaker. And are we able to expand on the law in a way that still admits the intent of the lawmaker? Because the US Constitution, when it was enacted several centuries ago, is still in force and is still being used as a means to, if you like, derive certain constitutional rights. So you know about the abortion debate, the Roe v. Wade, and how the laws on privacy were stretched towards protecting the woman's right of choice. And these are all examples of how, when the society is evolving, the law must also evolve to meet those needs. Education is a valuable tool to ensure that the law evolve, getting to that point. So having outlined the basics, meanings, points of interpretation, we can now go into a brief discussion on the approaches to interpretation. Any questions before we begin? Any questions for me, please? Okay, so we've taken away the, if you like, theoretical framework. We can now do the heavy lifting. There are various theories in which a judge can approach the interpretation of a statute or a document. There's the literalist or strict constructionist approach. There's textualism. There's originalism. There's political process. There's judicial pragmatism. There's living constitutionalism. There's the purposive and the modern purposive approach. You would go through Barak's formulation of the purposive approach and Benyon's view on the purposive approach as well. And then we'll look at the modern purposive approach as it pertains in Ghana. So let's begin with the first one, which is the literal or strict constructionist approach. Now, when it comes to literalism, I mean, every day we all use the term literally, literally. Like the name suggests, it requires you as a judge to give effect to the ordinary meaning of the text, regardless of the consequences. And literalism does not admit of any, if you like, views on possible mistakes or errors in drafting in terms of the document itself. The literalist will tell you that if you want to ascertain the true intent of the person who made the document, then look to the text. The text should be given its ordinary meaning. And the basic tenets of literalism are that once the text is clear and unambiguous, you do not need to look for a secondary meaning. So, an example of a literalist approach to interpretation we've seen in recent times in our Supreme Court is the case of ex parte Shraj, which is an interested party, where the court said that the word complaint used in Article 218A should be given its ordinary meaning. And it meant a formal accusation which is made by an identifiable person before Shraj. I mean, I believe that decision was per incurrum, and it has whittled down the powers of Shraj. But it goes to show you that in some instances, the literal interpretation may be used by the courts as a means to provide or determine the true intent of the lawmaker. It is not, as a matter of principle, it's now a settled question of law that when it comes to the approach to interpreting the Constitution, the literal approach is undesirable. So cases like Ransford France and Electoral Commission and Danso Champon and Attorney General against Abu Dhabi and a long line of cases would tell you that the literal approach is not a proper approach to use in terms of interpreting the Constitution. When it comes to, just a minute. When it comes to interpretation of statutes, we'll go deeper into what the literal approach to interpreting statutes are, but that is generally literalism, that it must be viewed as applying the ordinary meaning of the words used in the text as determining the true intent of the lawmaker. What is the difference between the ordinary meaning and the secondary meaning? Does anybody know? You see, oftentimes you see them say ordinary meaning, secondary meaning, blah, blah, blah. Okay, so let's look at the concept. So we are, yes, Tommy.
Telfer, what I know is that at any point in time, applying the ordinary meaning results in ambiguity or the meaning not giving clarity, then a secondary meaning would be employed to kind of avoid the ambiguity or the ambiguity. Yes, that is what I know about the secondary meaning.
Okay. So just to give effect or give clarity to what Tommy was saying, I bring this up because oftentimes the default position of literalists or the literalist approach to interpretation is that words must be given their ordinary meaning. But they are also happy to admit that once a text lends itself, or once the giving of the ordinary meaning to a text would lead to an absurdity, then it must be given a secondary meaning. What does the secondary meaning mean? The secondary meaning is some other meaning that the word is capable of. The secondary meaning is some other meaning that the word is capable of that prevents an inconvenience, injustice, or absurdity that might arise when the words are given their ordinary meaning. I'll take it again. The secondary meaning is some other meaning other than the primary or ordinary meaning, which will give effect to the text that prevents an inconvenience, injustice, or absurdity that arises when you give the words their ordinary meaning. So in effect, what we are saying is that if the primary or ordinary use or explanation of the phrases or words used in a DSC renders it subject to an absurdity, an inconvenience, or an injustice, then that will suggest that we need to apply some other meaning, and that some other meaning is what is known as the secondary meaning. What about when we say, please, I hope that is clear.
Yes, it's clear.
What about when we say fringe meaning?
Can I ask this question?
Yes, please, go ahead.
So, the election petition 2012, when the Supreme Court interpreted shall as may, can we consider it to be using the secondary meaning to interpret the primary meaning of the Constitution?
Yeah, I mean, I would not call that as use of the secondary meaning, because the secondary meaning of shall does not constitute may. I mean, shall imposes a mandatory requirement. So what I believe the Supreme Court did that in that instance was to interpret the Constitution in a way that didn't admit of literalism. So by viewing the circumstances of the case and understanding that the vote of an individual is sacrosanct and it must not be invalidated on account of, let's say, the indiscretion of an electoral officer. And so a purposive, a holistic view of the Constitution will lead one to the conclusion that shall should be interpreted as may. We'll come to that. We'll come to the discussion on the constitutional interpretation in respect of the word shall and may. It's a topical issue. But I would not say that is an application of a secondary meaning. I mean, there are litany of cases that you would see that outside some of those cases for you, and you'd be able to look at them. When we come to approaches to statutory interpretation, we'll go more into the literal meaning. I just wanted to give you a broad overview. So when we go more into that, that will make sense to you. I hope that's okay.
Yes, please carry on.
What about when we say technical meaning? Is there a difference between secondary meaning and technical meaning?
Yes, please. I think so.
Tell
I think
me.
yes. I think secondary meaning is any meaning outside the primary meaning, which if the primary meaning is not giving you, I mean, it's a little bit ambiguous and it's not giving you what you mean. So you resort to other means other than the primary meaning. But the technical meaning has to do with a specific field of study or area where they have certain terminologies or words that they use to mean certain things. That's what I know.
Excellent,
Thank you.
excellent. In any profession, trade, business, there may be certain words that are used that are specific to the trade, and the words may have gained the character of a technical word used in that profession, business, or trade. And so when the word has gained that character, you have to give the word the technical meaning in the context of that particular business, trade, or transaction. So what it suggests is that even though the literalists believe that the ordinary and grammatical meaning must be given effect to, when a word has achieved the status of a technical word in a particular transaction, trade, or business, the word will be given that meaning in respect of that particular transaction. So a group of merchants are used to referring to a certain type of transaction as A. And so the word A, when it comes to that transaction, means one thing. When it comes to the generality of words, the ordinary meaning of the words, it may mean another thing. Right? In context of the interpreter who has been called to interpret the document, if he's interpreting it in context of that particular trade, transaction, or business, he cannot give the words their ordinary meaning. He must give it its technical meaning within the context under which the parties themselves have ascribed to allow that particular meaning to apply to them. Please, I hope that is clear.
Yes, it's clear.
So who can tell me what the legal meaning is then? When we say the legal meaning of a word, what does it mean? I've said it this morning already.
I wasn't there.
When you apply the set of facts to the basic rules of interpretation to determine the intent of the lawmaker, what meaning have you gotten?
Okay, that's the legal meaning.
That's a legal intent.
That is the legal meaning. I hope this is clear.
Yes.
So your job as a judge is to always come to what meaning?
The legal meaning.
Legal meaning. So please, these are terms that you'll be coming across here and there, legal, ordinary, technical meaning, when you're looking at literalism and things like that. So again, just to sum up on the literalist point of view,
So
when the
Telfer,
text, yes, please.
So then it means that in all the approaches to interpretation of statutes and constitution, the whole essence of them all is to come out with the legal meaning.
Precisely.
Is that it?
Precisely.
Okay.
Okay. So who can, based on our discussion, who can tell me some of the criticisms? We've mentioned what literalism is. We say that the interpretation of words should be given their ordinary grammatical meaning when the text is clear and unambiguous. There's no need to look for a secondary meaning. But the instances where we may defer to a secondary meaning when a primary meaning will lead to inconvenience, injustice, or an absurdity. And there are also instances where when technical words are used, you ought to give the words their technical meaning. You may see the case of Monta against Patterson Simmons, where Boyson J, Mensa Boyson J noted that when legal terms or words are used, they imply their technical legal import, and so they should be used accordingly. Who can give me a criticism or a critique of the literalist approach to interpretation? I mean, just by discussing it, we have outlined some of them. So, any ideas? So, obviously, a defense of literalism would be that if you want to determine the true intent of everybody, just look to what the person has written. Do not attempt to go into the mind of the person and try to make any assumptions. But it's also important to note that literalism may lead to manifestly absurd consequences and instances, such that an ordinary meaning of the text may strip the text of its entire point and purpose. And so, just by applying the grammatical and ordinary meaning of the text, you are even losing the authorial intent. And remember that we said the whole point of interpretation is to come to the authorial intent. And so, any attempt at interpreting a document that effectively strips the author of the ability to give effect or better effectuate his intentions would not be in line with our goals for interpretation. Let's move on quickly to textualism. Textualism is also another approach to interpretation that is similar to the literalist approach to interpretation. It says that when looking at the meaning of the words, to be able to consider the meaning of a text, you must look at the ordinary meaning of the text within the context that it was used. Textualism is a school of thought that posits that in determining the meaning of a text, one should give effect to the ordinary meaning of the text within the context with which the text was used. So textualism is literalism plus context. Does that make sense?
Yes.
Literalism plus context gives us textualism. So just like literalists, they do not consider extraneous materials such as the memoranda, the preparatory documents, and everything else that is extrinsic to the document itself. They look to the document and they look to the document within the context in which the document appears and then determine the meaning of the words in the mind of a skilled, objective, reasonable user of the words. So they would make reasonable inferences, apply presumptions, linguistic canons, and maxims to arrive at the interpretation of the text. But what they would not do is to resort to extrinsic material and determining the meaning of the text. They believe that there's an objective meaning of the text, and so they do not inquire to questions regarding the intent of the drafters. But looking at the documents, and by not resorting to extrinsic or external aids, they are able to establish or determine the true meaning of the words just by the words in which, just by the context in which the words were used. You may see the cases of Saline Attorney General on the meaning of the words established, and you also see the case of Quenya and Archer, where the court explained that when it comes to the interpretation of a constitutional document, because it is sui generis, extrinsic aids and ordinary rules of presumptions of statutory interpretation would not necessarily apply. Is this clear? Can we move on?
Yes, it is. Yes.
Okay. So let me just clarify the textualism again. We've analyzed what literalism is. We've said literalism, plain,
Hello?
straightforward. Yes.
Please, in clarifying the textualism,
Yes.
kindly juxtapose it with the with the literalism,
Okay.
so that we'll see the lines clearly.
Okay.
Thank you.
Okay. So, like I said, they are very similar. They say that look to the ordinary meaning of the text to determine the intent, if you like, or determine the legal meaning of the text. But for textualists, the added, if you like, spice or recipe to what the literalist will do is to situate it in the context of the text. Every text, right? So for the literalist, they will take Kofi is going to school. What are we called upon to interpret? School. What does school mean? A place where people to go to attain educational facilities. End of. We finish our interpretation. But for the textualist, he goes a step further to say that Kofi is going to school was used in the context of a document, that whole document. So in that whole document, can we look to that whole document to evince the true intention of the word school as used in the document? That is what will enable us determine the true meaning of the text. So even though the textualist will not refer to extrinsic material such as the memorandum that was used in preparing the act or the legislative history or the purpose, they are not concerned about the purpose. If they are able to evince from the context of the words what an objectively reasonable user of the words will conclude in terms of the interpretation, then that is the interpretation or that is the meaning they will come to. So for the textualist, he's concerned with understanding the ordinary meaning of the text, situating it in the context of the words, and asking the question, an objective, reasonable user of the words, would he have come to this conclusion in interpreting the words? If the answer is yes, he has finished his interpretation. So unlike the literalist, who is concerned with the grammatical meaning of the words, the textualist is concerned with the context in which the words were used and what an objective-minded person would infer to be the meaning of the words in that context. I hope this is clearer.
Telfer.
Yes, please.
Yes, I get the point you're making, but let me see if what I'm saying also what I have deduced from your exposition would also help in a way, or I'm on the right path.
Okay.
So from the strict constructionist, they're only concerned with the ordinary plain meaning of the text,
Yes, please.
irrespective of whether it's absurd or what. They don't care. However, when it comes to the textualist, they look at the text itself, the context in which the text was used, as well as what a reasonable man would have perceived the text to mean.
Yes.
So if the reasonable man says that Kofi is going to school means that Kofi had moved from his house to go to a school to learn, then that would be the meaning they would advance to the text.
Yes.
So the difference between the strict and the textualist is about the reasonable man's assessment of the text. Is that
the
it?
reasonable man paying attention to the context?
To the context. Absolutely. I forgot that down. The context.
Yes.
Yes.
Please, I want you to repeat your exposition again. Those are the words that you used. So please repeat it for everybody's benefit.
Okay. So I was saying that what I gleaned from your explanation is this, that when we look at the strict constructionist, they look at interpreting a text from its plain meaning, whether it is absurd or it leads to absurdity or what, they don't care. They are only giving it its plain effect. However, when we talk of the textualist, they look at the text from the angle of the context in which the text was used, and also what a reasonable man would have perceived the text to mean under the context.
Okay. We're going to conclude.
No, it's okay.
Okay, all right. Thank you. Please, is this
All right.
clear now?
Hello, sir.
Yes, please.
Yes, can I also add that both the literalists and the textualists do not care about any secondary source or secondary material or something.
Yes, yes. That is
They are,
that is
they are concentrating on only the texts. And like my
exactly
brother said, within the context as pertain to the textualist.
precisely. Okay, so
Thank you.
Tommy and Faisal, thank you for your contributions. Proceeding, let's look at the intentionalists or intentionalism. Just by mentioning it, something should come to mind. What comes to mind?
Authorial intent.
Okay.
Or
So, okay, go ahead.
yes, intentionalist. What comes into my mind is intention, the
Mhm.
intent of the author of the document,
Mhm.
whether it's constitutional or statutory. That is what comes into mind. Knowing the intent of the author.
Okay, good point. But I want you to remember that I made the point that for the literalists and the textualists, they also believe that applying the ordinary grammatical meaning would give you the intent of the lawmaker or the person who made the maker of the document. But for the intentionalists, they go through an added layer. They adopt what is known as a three-tier approach to be able to determine the true intent of the framers of the law or the maker of the document. So, step one, they construe the text as a whole. The step one is to construe the text as a whole to ascertain the intention of the maker of the document. And to achieve this, they make sure that the interpretation is made as near as possible to the mind of the maker at the time of making the document. I'll take this again. To achieve this, they make sure that the interpretation is made as near as possible to the mind of the maker at the time of making the document. The next step that they will take is that the intention must be gathered from the written text only. We'll come to explain that much later. The intention must be gathered from the written text only. That is, the four walls of the document is what should help you gather the intention. And finally, the third step they take is that they would give words their ordinary meaning, and technical special words, they are also given their technical or special meaning. So what you realize from the intentionalist is an addition of the literalist approach, the textualist approach, and then an added incentive or an added, if you like, ingredient of ascertaining the intention by providing an interpretation that is as close to the mind of the maker of the document as possible at the time of making the document. We'll come to explain this much later. So, for instance, the first rule that the intentionalist approach adopts is what is known as the mischief rule, which was developed in the Hayden's case. I'm sure many of us are privy to the Hayden's rule by now. Can anybody tell me what the mischief rule in the Hayden's case is? The mischief rule. Any ideas? Oh, nobody. Mischief rule. The mischief rule is simply to the effect that at the time the law was made, the legislator or the parliament.
Someone's
Okay,
hand is up. Oh.
okay, who? Eugene, please. Eugene Edu, go ahead. Sorry.
Hello.
Yes, Eugene.
I wanted to try and explain the mischief rule.
Go ahead. I beg you. Thank you.
Yes. So we look at the time the law was passed. Was there an issue that the law sought to correct? Was there a defect in an existing law, or there was no law? So a new law was enacted to settle a certain misunderstanding or whatever that existed at the time. That's what I understand by the mischief rule.
Exactly. So what was the defect in the law? What mischief, if you like, did the legislature try and cure by passing the act? That is what will help the interpreter know that the act was enacted to be able to cure a certain mischief. So if you know what problem the act was enacted to solve, that will help you understand how to approach interpreting the document. And that is known as the mischief rule. The second rule of the intentionalist point of view is what is known as this, the literal rule. We've explained the literal approach, and it was developed in the Sussex peerage case, which requires that interpreters read the document and give the words their ordinary meaning within the context in which they are used. You need to be able to add that, and that technical words are also given their technical or special meanings. The third rule, which the intentionalists also approach in terms of interpretation, is what is known as the golden rule. Who can tell me what the golden rule is? We have said it here. We have already discussed it here.
Telfer.
Yes, Tommy.
Yes, I remember you said where interpreting a word or a text, it happens that it will lead to absurdity.
Mhm.
Then either a word may be changed so as to avoid the absurdity it may represent in interpreting in its plain language. And so what the golden rule seeks to do is that where interpreting a word will lead to an absurdity, then the interpreter must change certain words that will make it more meaningful and to avoid the absurdity it initially had.
Excellent. So the golden rule, Gray and Pearson, that is your authority for that. Give the words their ordinary meaning, but where the ordinary meaning will lead to an absurdity, give it some other meaning, which is the secondary meaning, which will avoid that absurdity. And also, technical words should be given their strict technical meaning. So, I mean, these
But
are
Alpha,
yes.
I want to say something. I
Yes.
realized I stand to be corrected, but I realized from your explanation of the intentionalist
Mhm.
approach, they seem to be in alignment with the approaches to interpretation of non-statutory documents from the pointers you gave, especially from the case of Biney and Biney. The
Yes.
fact that the interpretation must be near to the minds of the author, the fact that the document must be read as a whole, the fact that the interpreter must look to the instrument to derive the interpretation, and the technical words being given their technical meaning as well. It looks
Yes.
as if the intentionalist approach to statutory and constitutional documents.
Hello.
My mistake. Hello, Telfer, can you hear me?
Yes, Tommy. Please finish your point.
So I'm saying that it looks as if from your explanation of the intentionalist, it's more aligned with that of the approaches to non-statutory documents.
Yes, that is so. That is
Okay.
so. When we come to discuss the approaches to interpreting NSC, so non-statutory documents, we would make a deeper delve into that. So that is so. Eugene, you have a question?
No,
Okay.
Eugene raised their hand previously, but he hasn't let it down.
Okay. All right. So these are the basic approaches I wanted you to look at. There are others. There's the originalism, political process, judicial pragmatism. I think that those ones you should read. Tomorrow, when we set out, we would spend some time discussing the purposive and modern purposive approach to interpretation. The reason we'll spend time on it is now it's a settled matter by the Interpretation Act and our Supreme Court that the preferred approach to interpreting statutory and constitutional documents is the modern purposive approach, or the purposive approach to interpretation. And so tomorrow we'll spend some time discussing the purposive approach and the modern purposive approach to interpretation, and that will conclude our discussion on the approaches to interpretation. And then once the exigencies of the time allow it, we'll also then begin to look at the construction of non-statutory documents, NSTs, as well. So thank you for, unless there's a question, is there any question, contribution, comments, additions, suggestions, revisions, anything you want to? Yes.
Yes, please.
Faisal, please go ahead.
Yes, my suggestion is we plead with you to float this audio so that we can listen to it again and again.
Okay. Yes.
That's if
I'm
we recorded it.
yes, I'm reliably informed that Mr. Fatah Mahama recorded it, so I'm sure he'll take steps to share it with you as well. He's organizing these sessions, so I'm sure he would provide that recording for your benefit as well. Tommy, you had a comment?
Yes. I joined pretty much late, but I don't know whether you touched. When I joined, I heard you speaking about latent ambiguity and what is it called?
Patent ambiguity.
Patent and latent.
Yeah, so I was just let me make the distinction.
No, not. I'm not even. My concern is not even about these two. I remember in our class, our lecturer made mention of other two types of ambiguity, the semantic ambiguity and then the syntax.
Yes.
I don't know whether you touched on it.
I mentioned it, but I didn't go into it. So
okay, it's fine.
Remind me first thing tomorrow we'll go into it.
All right, sure.
I'll mention it briefly and then we'll spend some time on it.
All right, sure. Okay.
Any other comments, contributions, questions? Great. Thank you for your time. Same time tomorrow. See you guys.
All right. Thank you,
Senior. God bless you for this. And Fatah Mahama, God bless you for this. Thank you.
You are welcome, my senior. So thank you, and have a great day. Bye. And yes, I would make the recordings available, so I'll share it with my seniors who are in part 2, so they can also share with you. Thanks.
All right.
Thank you.
Thank you very much, Fatah.
Have a wonderful day.
Almost finished.
Yeah, no, yes, a price kicker. Queen good free.